Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. We'll hear arguments in three cases this morning. First is 20-857, JBrice Holdings versus Wilcrest Walk Townhomes Association from Harris County and the 14th Court of Appeals District. Then 2136, Prohibit versus Baylor Miraca Genetics Laboratories from Harris County and the First Court of Appeals District. And finally, 20-898, Rosetta Resources Operating against Martin from Live Oak County and the 13th Court of Appeals District. The court is allotted 20 minutes per side in each of the cases, and will take a brief recess between the cases, completing the arguments before lunch. The arguments are being webcast live this morning on the court's website and will be available later in the archives. We're ready to hear argument in 20-857.
May it please the court. Mr. Sutton will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. The question before the court this morning is whether buyers of real property are entitled to rely on the restrictive covenants that are in force on the date they buy that property. This morning, I'll first address why they must be able to rely on those, and second, the constitutional ramifications if they cannot. When someone buys a home, piece of real property, by law they are on notice of all restrictions that are on record with the county clerk as of the date they purchase. Equally, they rely on those restrictions. They rely on them to understand what they're buying and how to price it. So you might buy a piece of property which contains the right to lease. You might buy a piece of property which allows you to have horses. You might buy a piece of property in a residential subdivision that nevertheless allows you to operate a business, a commercial business in that subdivision. The restrictive covenants in this case, and the dispute is about leasing, and to rehearse very briefly because I think it's important, the restrictive covenants in three ways tell us that not only do you have a right to lease, but you have a right to lease for short terms. First, they restrict everyone to private residential use. However, they include the word tenants as part of the allowed private residential use, so we know that leasing is allowed. Second, perhaps most importantly, they say that leasing, apart from certain formalities, is allowed without any restrictions whatsoever. Finally, the drafter thought about temporary residency in these homes, and the drafter said, the only places you can't live temporarily on these properties is in buildings other than the main dwelling. The right to lease is a fundamental, foundational property right. This court said in Spann versus City of Dallas in 1921, and it's worth quoting here, the right to acquire and own property and to deal with it and use it as the owner chooses, so long as the use harms nobody, is a natural right. It does not owe its origin to constitutions. It existed before them. It is part of the citizen's natural liberty, an expression of his freedom guaranteed as inviolate by every American Bill of Rights. We have similar language from the U.S. Supreme Court in Terrace against Thompson in 1923, and even earlier by this court in Caucasia Lumber Company, that's from 1890.
Can I ask you, so I think the crux of the argument is that the language in this covenant was different than the language in TAR, and that's why there's should be a different are that different than what you want to happen. What is your response to that?
You anticipated my next point, which is actually there is no difference between this case and TAR, and here's why. The language in this restrictive covenant is not, properly speaking, a restriction relating to leasing. What the developer says is, there shall be no restriction on an owner's right to lease. In 1976, the developer was talking about a 1,000-year-old right that dates back to William the Conqueror. Everyone assumed that if there was nothing in a set of restrictions, as in TAR, about the right to lease, that it was there. And so this is really not, in some sense, a case about how you interpret a restriction.
Well, you do agree that there shall be no restriction on the right to lease other than the foregoing, which incorporates the residential use clause, right?
That's correct. So the restriction is residential use.
It's not totally unrestricted. It's unrestricted except as otherwise provided in the CCRs, which include the residential use clause.
Well, what the leasing clause actually says is, apart from the foregoing three formalities, give a copy of the lease to the HOA, include a default provision. I don't know that that clause more broadly says apart from all other restrictions, but I do concede the point that the restriction that's important here is residential use, actually private residential use only. And my argument is that leasing has always been part of that.
Yes, I mean, certainly the restriction in what I'm calling the residential use clause says that it can be used as a private single-family residence for a tenant.
That's correct.
Right, and so that's your point, is it clearly encompasses the right to lease within the CCRs themselves.
That's right, and that's why it's the same as TAR. I don't think you can make a distinction. This, in thinking about TAR,
it says used as a private single-family residence. So do you think they could prohibit, 12-man bachelor parties, but perhaps not, a single family doing a short-term rental?
Justice Blacklock, you've asked a question that begs some constitutional issues. These were addressed.
Well, let's maybe address that secondarily, but just under the text of the provision, do you think, because it's limited to private single family, they could limit some short-term rentals, but not those to families?
I believe that what the cases tell us and what TAR told us is that a buyer on notice of a restriction takes subject to that restriction, assuming that it's, one, clear, and two, does not otherwise violate a public policy or the law.
Is single family,
I didn't get an answer that I heard.
A buyer on notice of restriction does take subject to the restriction, and so if Mr. Brice had bought a property that said no short-term leasing, he's clearly on notice, and unless I have some argument that that's against public policy, then he would take subject to such a restriction. And I believe what's developing in the law are some constitutional concerns about those kinds of restrictions, but you've asked me to set those aside. And so the snapshot in time that matters is the time when you enter into that contract. You pay $500,000 for a piece of land. You're on notice of what's in the county records, the restrictive covenants of record for that property. If it says no leasing, there's no leasing. If it says no parties, there are no parties. I hope that answers your question.
Well, the question was, it says single-family residence. And so is there a distinction between leasing to a single family and leasing to a big group that's going to have a party?
In this case, the single-family restriction is my recollection in this case is a construction restriction as in TAR, but there are many cases where single-family is bound up with the use restriction. And so the question has become, and we are litigating this, what constitutes a single family? And I believe I understand your question now, which is a bachelor party a single family? No, a bachelor party is not a single family, and furthermore, it's commercial use. You've turned that property into an event venue. And so all the concerns that we hear about ruckuses and parties at these houses. And I was asked last week in the Beaumont Court of Appeals, well, what about 1 hour rentals? Well, 1 hour rentals and parties every weekend show that that house is being used as a commercial event venue. It's not being used in the way that people ordinarily use houses anymore. We all expect that a landlord, in leasing out a home for residential use, whether it's a single-family restriction or not, is going to rent to people who use that house like anyone else would use coming to live in that neighborhood. And I think that's the key to understanding these cases and why the right to lease encompasses short-term leasing as part of the bundle of rights, but does not allow anyone to abuse the privilege of using a house for residential use.
You have to look at the rest of the clause to decide what single family means, because it does say the owner can have guests, which I assume doesn't mean only guests that are part of his or her family.
One of the tensions in the short-term rental cases is if someone leases a house for a week, and I'll give you my own example, we rent a house in California every year, but sometimes friends of ours in California come to stay with us in that house for 1 or 2 of the nights, so those are our guests. So you might have a fact pattern in a given case where someone rented to unrelated people as a subterfuge to get around the restriction. And that's going to be a fact inquiry in cases like that.
But do you think that the only people that can be rented to under the tenants provision are tenants that comprise a single family? Or do you think by mentioning guests and tenants that establishes a context for single family that's like a single family, but not all the people who are renting or who are guests have to be related to you?
Okay, as a baseline, I think the single-family use restriction has grave constitutional problems, and I think in the years ahead we're going to see that play out. But if we assume for the sake of argument that single-family as a use restriction means something, then I think the definition most of us are assuming applies is some form of close affinity, blood, marriage, adoption, something that shows those people had a pre-existing relationship. The lease is going to be to a person who signs the lease, and that person under these restrictions has to commit to complying with the restrictions. And so the lease has to say, we're going to have a single family staying here, whatever that means. Now, can they have a guest? I think under constitutional law, they have to be able to have a guest, and under the Zatari decision out of the Austin Court of Appeals, you trample on people's rights if they don't get to have guests in their own home. It's a leased home.
Your point, though, is really that regardless of the restriction the single-family residence use might place on a leasehold, on a person who rents, it says nothing about the term, the lease term.
Correct. The relationship of people has nothing to do with the duration of a lease.
What is, will you flesh out for us your understanding of the sentence at the end of the residential use clause that says that no building plot shall be used or occupied for any business or commercial purpose, either apart from or in connection with the use thereof as a residence, which seems to say, even if it's to be used as a residence, it can't be used as a residence for commercial or business purposes, which I'm envisioning, you know, I moved to a different house, but instead of selling my property here, I create an LLC and I lease it out for a year at a time. Am I using that as a business purpose, but in connection with as a residence?
Well, no, not under these restrictions, because these restrictions expressly allow ownership by entities. And so if the mere ownership by an entity were the issue, it wouldn't matter under these deed restrictions. But more fundamentally, the issue is this. All kinds of entities own houses. The McDonald's Corporation could own a rent house.
What does it mean that you can't use it for a business or commercial purpose, even in connection with the use as a residence?
That the property itself cannot be the location of an operating business. There can't be, as the Chief Justice asked me in the Tar case, there can't be a leasing office in the back where people come and go. But in cases like this, the leasing is all done online, even if it weren't.
We're all working, or at least have been, working from home a whole lot more in the last couple of years, and we're not a good example because we're probably not a business, but if I work for Dell, but now I'm working from home, am I using the property for a business, commercial, trade, or professional purpose in connection with its use as a residence?
Yes, and there are many older deed restrictions that are going to cause friction because people are now working from home. More modern deed restrictions have many carve-outs, and they'll typically say something like, you know, a business that cannot be apprehended, seen, even smelled from outside the house is okay. Probably the law has to catch up with what is happening with people working from their homes. I also work from my home.
So I can work from an office in the back of the house, but I can't put a shingle on the front door that I'm selling puppies or something out of the house? Is that?
Well, under these restrictive covenants, you probably can't work from the house if you're running your law practice and taking phone calls and faxes, and certainly if clients start walking up to your house, you're going to run into a problem.
So then why does that not apply if I'm not living there, but I'm renting it out as a residence in order to make money?
The transaction's not occurring at the residence. All that's happening at the residence is tenants are living there. So under your analysis, or the analysis you're suggesting is that every home that is an investment home becomes a business by virtue of being rented out. That can't possibly be the law. The transactions occur somewhere else. The lower courts in this case did not give effect to the right to lease with no restrictions. I think that's clear. The question is why? And I want to suggest to the court that the answer lies in TAR. TAR reaffirmed a principle, a very old principle, that restrictive covenants, the restrictions on the use of land, are disfavored in the law. And they're only going to be enforced if they're clear. And if the buyer had notice of them at the time of purchase. I believe, because of the kinds of pressures identified by Justice Boyd, that lower courts in this state are applying the opposite of that rule. And so that now restrictive covenants on land are now favored, and we will look for that interpretation which allows us to further restrict the use of land if we can find an argument to do it.
Your time has expired, Mr. Sutton. Are there any other questions? Thank you. We'll hear from the respondents.
May it please the court. Mr. Weinberg and Ms. Denton will present argument for the respondent. Mr. Weinberg will open with the first 10 minutes, followed by Ms. Denton.
May it please the court, good morning. With all due respect to Mr. Sutton, none of what he just talked to you about was addressed in the Court of Appeals. This is not son of tar, okay? This is a case where the legislature published and enacted Property Code 204, which said that homeowner associations, first they said it in 1995 in Harris County, and then they extended it to Galveston County, and then because Montgomery County has a national force, they extended it to Montgomery County and said that associations, because we all recognize that much of people living in this state, and particularly in those counties, are living in places where there are not city ordinances and zoning. And so you've got to give some latitude to a homeowners association to change with the times. And that's what exactly happened here. I do believe that the Court of Appeals can be affirmed based on what y'all are talking about, which so far seems to be the residential use restriction, which, by the way, to contradict Mr. Sutton, it is not a building requirement, although that's in there. It is actually under the heading Article 9, use restrictions. Okay, it's not like TAR. And Ms. Denton, who's going to address you in a bit, will talk to you more about why it's not like TAR. But we have a rule that was passed by this association because they listened to you in TAR, and they said, because you said be specific. And they said we have Property Code 204 that allows us to be specific for the welfare and the health and everyone in the subdivision.
The property code says unless otherwise provided by
Correct.
restrictions, and the restrictions say there shall be no restriction on the right to lease. So
Well,
what do you say?
first of all, this is not leasing. This is hoteling and transient use. This is like,
I mean, is that your answer? That your case rises or falls on whether this is leasing?
to a certain extent, Your Honor, because first of all, you got to look at that provision that's in the deed restriction. Once again, these deed restrictions have headings, and they don't say in here that the headings are not important, ignore them, anything like that. The one that talks about leasing, All right, there shall be no other. It's buried in the middle of the mortgage provision. In fact, if you go to Article 11 and you start reading that section, and you're looking to buy a piece of property, you're going to quit reading because it applies to mortgagees. And you're going to quit reading, and then all of a sudden, wow, there it is, right there in the middle. But it also requires other things. It also requires that your lease be in writing. Number two, that the lease be provided to the association. That's never happened in this case. We have it in the record on appeal. I believe it's page 32 and 35. The association has no idea who Mr. Brice is renting to and hoteling there. The residents in this association, by the way, these are 1-story, 2- and 3-bedroom townhouses located in the tourist mecca of Houston, which is north of I-10 and just east of Beltway 8. I don't know of a single tourist thing there. This is not a beach house. This is nothing but a neighborhood. And what you have in the record on appeal was they wanted this rule passed because they're concerned, security concerns. Who are these people wandering around using the push pad at Mr. Brice's townhouse to come in here? Who are these people who are bringing additional vehicles and creating an even worse parking problem than we had to start with?
So the restrictive covenants provide for breach of the lease when there is a lease agreement, and I know you dispute whether these constitute lease agreements, but for annoyance or nuisance, and that can be determined in the association's sole discretion. And same with parking. There's significant parking restrictions. So why don't those things provide the protection from the sort of character change in the neighborhood that you are voicing the concern about?
Some of them do, but let's look at when these restrictions were enacted. This is an association older than TAR. This was 1976. And again, we're trying to find the intent of the drafters, but again, I'm saying you can decide this under the deed restrictions as they were, I believe, but the Court of Appeals addressed the fact that we're dealing with Property Code 204, which says unless otherwise provided, and we don't believe it was otherwise provided having anything to do with hoteling or somebody being a transient. But if you go back to 1976, what was a lease? What was a lease back then, and what the drafters considered, was somebody who is coming in, you're going to lease your house or your townhouse. It's going to be a longer duration than a couple of nights because it just wasn't physically possible to do that back then. We didn't have iPhones. In fact, in 1976, Apple Computer was created. I mean, we didn't have it. So now we have a situation where it used to be if you came to Houston and you wanted a place for a couple of nights, you went to a hotel. Now, with Airbnb and these other things, yeah, there's a way to hook up and find other places, but why in this neighborhood that clearly doesn't want it? And they've made that very clear with a rule they enacted under Property Code 204.
And so what is the word that you would use to describe that activity of leasing, but it's not leasing, you're saying, when somebody rents a hotel room?
When I rent a hotel room, which I did last night, they actually provided me shampoo, very much like
But
JBrice
what's the
did.
word for that? What's that called?
That is
What is
actually
the
a
owner
license.
doing?
That is a license.
Are they leasing the property? Are they renting the property out? What are they doing?
They're providing a license to people to have a room for the night.
But what's the word that describes that?
Be hoteling or transient use. Our case law has indicated, for example, a halfway house is not a lease agreement. That's in Hunt versus Airline House. The property code defines temporary housing as hotels, motels, inns, or similar transient housing. That's property code 92.152 little a.
Did we reject this sort of characterization of these short-term leases in TAR? Are we bound by what we did in TAR in terms of the character of the use here?
Of course, TAR didn't deal with a 204 rule. They didn't mention 204. They were dealing with 202 and how we should interpret these restrictions. And they were focusing on the word residential use, and they talked about people eating, sleeping, and drinking there.
And sort of exclusive occupancy.
Correct. But we have a different situation here. We have a different use restriction that is clearly under use restriction and not under building restrictions. We further have not only the use restriction, but we also have a rule that's been enacted under 204. And we clearly have enacted a rule that talks about something that wasn't talked about in the original deed restrictions, and that is hoteling and transient use. I was going to allow Ms. Denton to talk about the other issues about how this is not TAR. Thank you, Your Honor, unless there's another question.
Any other questions? Thank you, Mr. Weinberg. Ms. Denton, we'll hear from you.
Good morning. May it please the court. So, right, I want to talk about a few different reasons why this is different from TAR. And Justice Bland, you brought up a great point about the nuisance and annoyance provision. In this case, the association asserted that JBrice's hoteling Airbnb activity violated multiple provisions of the restrictions. There's the residential use provision, there's the not operating a business, there's also asserted that he was violating the nuisance provision and the annoyance provision of the restrictions, as well as the rules. On appeal, it was Mr. Brice's burden to challenge all of those independent grounds that could support the judgment.
Well, your judgment says, though, that those claims were non-suited.
We believe it just says that the private nuisance claim was non-suited, but the claims for breaching all the different parts of the restrictions were still in effect.
But did you obtain relief or findings of breach? I'm not talking about findings of fact and conclusions of law to support the claim, but actual judgment on a claim other than the injunction limiting it to 7 days in terms of imposing a short-term rental provision.
So I believe that those injunctions, which are finding that he was operating a business, he was operating it as a commercial business, and that he was using it for short-term nightly hotel transient use, is violating the use restrictions and also could support violating the nuisance and annoyance provision by finding him operating a hotel, which was a nuisance and annoyance to the association. So that's one reason, too, that this is distinguishable from TAR. We have more provisions than just the bare bones.
Your position is that the judgment that the trial court rendered was was relief that was granted for violation of other lease provisions.
I believe that that can be supported by the judgment, and all the implied findings have to support the judgment. So going back to why TAR is also distinguishable, as Mr. Weinberg discussed, the Court of Appeals decided this case only based on the rulemaking authority under 204.010. With the legislature passed the statute, they recognized that it was important for homeowners associations, especially in Houston where there's no zoning, to have additional powers in being able to change the restrictions with the times as things go. With 204.016, that they provide that unless otherwise provided by the restrictions, the association has the authority to regulate the use of the subdivision. So the Court of Appeals recognized that this is a restriction on hoteling and transient use, and that wasn't conflicting with the underlying restrictions, and so the association was allowed to pass the rule.
It's your position that the restriction against use for any business, commercial, trade, or professional purposes is distinguishable from what we discussed in TAR because it expressly addresses use and not the type of building, essentially, right?
Right. That's one of the reasons.
Assuming that's correct, that it restricts use so that you can't use the property for any business, commercial purpose, your position is the petitioner here is using the townhome for a business or commercial purpose because they are hoteling it out on a short-term basis. And which then begs the question, well, but what if he was, where do you draw that line, right? If he was doing it for a 6-month lease or a 3-month lease, why would that not also be a business, commercial purpose in connection with its use as a residence?
Sure. So I believe Texas case law and the statutes have long made a distinction between the sort of transient use that we have here with the Airbnb and legitimate long-term leasing. As Mr. Weinberg discussed, there's the cases that say, you renting a hotel room is not a lease, that's not a landlord-tenant agreement, and then also kind of a halfway house, other transient parts are not those. The case law also shows that it's pretty well established that when you are like a typical landlord who rents out a property for, or leases out a property for 6 months, a year, or long-term lease, the primary purpose of that is using it as a residence. And the fact that the landlord is making a profit on the side is incidental to that. That doesn't change the character of the use from residential. But here, that's not what's happening. Mr. Brice is operating both of the properties as a hotel alternative, and the people who are coming to stay there are using it as a hotel. They're not using it as a residence. So that's why it's distinguishable, at least from legitimate leasing, where the tenant is actually using that as their residence.
But couldn't that also be the case with a family who comes to rent it for 14 days?
No.
I mean, there's a 7-day line, right?
Right, that's what the
and
trial
so
court
why,
put in there.
it seems like that, it goes back to the line drawing problem that Justice Boyd raised. If you undisputedly have a single family who's living there for 14 days because their child's getting treatment at MD Anderson, that's not a commercial purpose, but why, the landlord is making money off it either way. I guess I'm just having trouble drawing that line. If we say that one lease, that the duration makes it business or not, I'm having trouble with that.
I don't think that it's just the duration that makes it business. I think, as Tar explains, that you have to look at factually specific cases when you're analyzing deed restrictions and determining whether something violates the restrictions. You can't make these wide sweeping claims that short-term leasing is allowed every time you just have a plain residential use restriction. You have to look at the specific facts of what's going on. And in this case, we have the Airbnb for 2 to 10 nights, which we consider to be the business use. In the other cases, again, you'd have to kind of look at what are the specific facts going on there in that case. And then I don't think it just goes straight to the duration on that. But then also in this case, we have the rule that the association passed, which set out 30 days based on what the tax code says about what constitutes a hotel or transient use.
Could that be why they say in the restrictions, otherwise there shall be no restriction on leasing, to avoid having to draw these lines?
I don't know if that's why that provision is in there necessarily. I just don't think that this is leasing, so in that case, that provision kind of doesn't apply. You were just looking at whether the rules were passed validly, and the Court of Appeals found that they were, that there wasn't anything in the restrictions addressing transient or hotel use, so the association was allowed to pass the amended rules, which specifically set out what counts as actual leasing and what doesn't, to clarify any sort of issue.
Well, the rule is keyed off of a 30-day period, but the trial court's judgment that the Court of Appeals affirmed implements a 7-day duration. Mm-hmm. What is the basis for that?
So the trial court came to that conclusion based on the evidence and the arguments at trial of what was going on, and used their discretion to come up with a 7-day limitation on the injunction. I believe the permanent injunction has to be reviewed for abuse of discretion standard, which I don't believe JBrice challenged that on appeal. But I do believe the trial court was within its discretion to come up with the 7 days. But that's just, for the duration of the short-term occupancy. But even if without that, the injunction still prohibits him from operating the Airbnb businesses on there. So I think even if that provision was not in there, the injunction still stands to prohibit his Airbnb use.
A process is available for, or is a process available for amending the CCR?
Yes.
What would that entail under these?
I believe it's a pretty standard amendment clause. I apologize, I can't remember what the exact percentage is to have everyone vote on it.
A certain percentage of the residents or owners to agree to those amendments?
Right, if you're actually amending it, but the association board has separate authority under 204 to pass the rules, which can further clarify the restrictions as long as there's not a direct conflict. And I think that's the key here, is that a direct conflict, and we say no, that you can reconcile these provisions together with the leasing restriction that's in there and amended rules, which say that short-term rental hoteling is not a lease and that it's not allowed if it's not for 30 days. So in conclusion, that TAR is distinguishable from this case. The Court of Appeals didn't even reach TAR to begin with, and then even if you do find that TAR is applicable, it's distinguishable based on the language of the actual restrictions here, which we've gone over, that don't allow no owner to occupy it for any purpose other than a single-family residential home. And I think that's a key distinction from TAR. And there's no other questions.
Any other questions? Thank you, Ms. Denton. Mr. Sutton, you have 5 minutes.
Justice Boyd, quickly, I want to address something that you asked about amending. I want to mention to the court the wider jurisprudence right now. There are a lot of pieces on the chessboard. I have 20 cases pending around the state which ask the following question. If, in a case like this one, the owners vote, 60% of the owners voted to take away the right to lease, would that be enforceable against someone like Mr. Brice? I don't want to prejudice the court with what, I think the answer is and what's going to happen, but that is coming down the pike, and it is being fought all over the country and all over this state. Does the amending clause of restrictions, in essence, gut the rest of a set of restrictive covenants, is the question that you've asked. So that will be coming up. Second, I want to briefly talk about Brooks against North Glen, this court's decision from 2004 under Chapter 204. Unless otherwise provided, the reason that's there is to avoid constitutional infirmity. It's to avoid contracts clause violation. At the tail end of Brooks against North Glen, the court pointed out, we're not going to interpret a statute to invite a constitutional problem. And if in that case there was no, excuse me, I need to grab my notes. I forget the language. There was not a substantial impairment of contract rights. It was a question about a late charge. Well, leasing is one of the most important rights we have. So under Chapter 204, unless otherwise provided, is the escape hatch to protect important rights like the right to lease.
If we call these leases, do we end up incorporating landlord-tenant law in some ways that might look odd as applied to a 3-day lease?
Justice Blacklock, that is an important question. I still have not seen these disputes arise, but the question like eviction. So, sometimes the short-term landlords will say, well, I'm going to come and bounce you out 2 days after you get in if you violate the lease. Well, that's not what landlord-tenant law says. You have a process for that. As a practical matter, it has not yet arisen, but I would expect it to arise at some point in the future. I believe all the landlord-tenant laws apply to short-term leases, and landlords have to be cognizant of that.
What do courts around the country, it sounds like you're involved in a lot of these cases, what have they said about whether whether an STR is not a lease, but is a hoteling?
Okay, so at the time of TAR, we had something like 15 or 18 cases which held squarely that leasing for short terms is still a residential use. One or two courts.
Not residential use, I get that, but is it a lease? Is it even a lease as opposed to, like if you stayed in a hotel last night, I assume you agree you didn't lease that hotel room, or you think you did?
That's a license.
Okay, so what if courts are, and their argument is, well, so is a 3-day rental, so is a 6-day rental. And what have courts said about that? Is that a lease or a license?
No, it's a lease, and what happens is you have to convey the entire possessory interest of the property to the person who's allowed to use it. In this case, a single family signs the lease. They have the possessory interest. The landlord doesn't get to walk in like the owner of a hotel, control the hallways, the kitchen, anything else. The tenants have the house, the full possessory interest for the term of the lease, period. No one's running a business
Can they
there.
attach a TV to the wall or trim the hedges or really act like a a full tenant?
My position is they are tenants subject to the terms of a lease. If the lease says they can't trim the hedges, I suppose they can't trim the hedges. I have not seen that fact pattern. But my position is they have the full possessory interest, and the landlord is not entitled to set up cameras and watch them or walk in the house and see what they're doing in the bedroom.
If a lease says that they can.
Problems arise in the nitty-gritty details of leasing for short terms that I don't know the details of because I'm focused on the larger issues. I can't answer your question. I've never seen a lease that looked like anything other than conveying the full possessory interest and has the usual hallmarks of a lease, except for the term, which is short.
What if you're renting a room in a house, and sometimes on Airbnb and VRBO you can get a room, and maybe that comes with certain rights to use the kitchen at certain times and things like that, lease or license?
That's not a single-family use, and the case law addresses boarding houses. So my clients who have short-term leases can't run boarding houses.
So that's a license.
That's a license. Yes, that's exactly right. Finally, I'm out of time, but the court needs to be aware that the hotel tax applies to residences specifically. The legislature doesn't think that a residence becomes a business just because someone pays the tax that the legislature wants to raise money. So if we interpret the hotel tax, as the Court of Appeals did, to ban to call every house a business once they pay the tax, well, then you've just cut off your nose to spite your face. And so we all know what a hotel is. Short-term rentals are a use that goes back time out of mind, as recognized by Zatari. The issue is the internet. They're more prevalent now, but they have always been there. Every owner has always had the right, under our jurisprudence, to decide who and when to lease. It is a fundamental aspect of property rights.
Any other questions? Thank you, Mr. Sutton. The case is submitted, and the court will take a brief recess.
All rise.